Hi, my name is Alexis Stevenson, and today I will be doing a lecture of the timeline of special education law. Starting with Brown versus the Board of Education, according to NAESP.org, the case was decided on May 17, 1954 by federal law. At this time, schools had the option to decide if they wanted to participate in special education intensive programs throughout the mid-60s. This ruling led to further acts that led to IEPs, abolished the separate but equal doctrine. As for free and appropriate education, up until 1975, nearly half of all children with disabilities were being either inappropriately educated or completely withheld from public schools. Students with disabilities were for the majority separated from their typically developed peers. Students with disabilities were not integrated in mainstream classrooms, not providing them with their least restrictive environment. Teachers were seen as the experts. Parents were not viewed as equal members of the child's care team. Parents were sometimes blamed or shamed for having a child with a disability. After Brown versus Board of Education, there was a push for equality for all people, regardless of race, gender, or disability. According to the Department of Health and Human Services, this act is the foundation of acts that support equal rights under the law. Since FERPA and later HIPAA were not yet passed, student information was not legally secure. Transition services for students coming into adulthood were lax, as independence was often viewed as not possible. Discipline was decided by teachers and administration, often leaving parents with little to no say. The impact Brown versus Board of Education had on the field of special education for students and parents is immense. This decision had a ripple effect for further equality acts. Students with disabilities were beginning to be taught as equals, making learning the goal for all students, not just for those who develop typically. Next is the Park versus Pennsylvania. According to Arizona State University, Pennsylvania Association for Retarded Citizens, PARC, versus the Commonwealth of Pennsylvania was passed in 1972. This decision claimed that states could not withhold a person's right to equal access to education on the basis of developmental or intellectual ability. This case made schools legally obligated to accept all students, no matter their ability, a prerequisite for free and appropriate public education, FAPE, which according to EBSCO was passed in 1975. Students with disabilities post-Park versus Pennsylvania were allowed to attend school without discrimination based on attendance. However, students with disabilities were mostly educated separately from their typically developing peers, therefore not provided with the least restricted environment. It was considered appropriate for schools to evaluate their students with disabilities at least every 2 years for classification. Parents of 14 intellectually disabled children were denied free education in Pennsylvania, so they partnered with PARC to sue Pennsylvania. Teachers were legally obligated to participate in the education of students with disabilities. According to Study.com, before this case won, children who haven't attained a mental age of at least 5 years old were denied the right to education. This procedure was outlawed post-Park versus Pennsylvania. According to Forte Law Group schools, before Park versus Pennsylvania, psychologists could label a child uneducable and untrainable, and not provide them with an education or to indefinitely postpone admission to public school. Procedural safeguards included the legal right to have equality in education regarding race, gender, and developmental and intellectual disability status. According to the Center for Parent Information and Resources, procedural safeguards including families and schools mechanisms used to resolve disputes. Confidentiality regarding student information was not yet legally protected. Transition services were becoming more widespread as all students in special education were being educated. Discipline was carried out by teachers and administration. This case impacted teaching and learning by making it a legal right for children with special needs to attend school. All children were no longer identified as uneducable or untrainable. The hope towards independence started to become more widespread. My choice law was the Family Educational Rights Act, FERPA. According to public health law, FERPA was enacted in 1974. This law impacts IEPs as it protects all student personally identifiable information. If a school does not follow FERPA, it could lose all federal funding. FERPA impacts FAPE by protecting the personal information of the student, who has the right to a free and affordable public education. The IEP has the information of what the student's least restricted environment is, and that information is protected under FERPA. Parents and teachers both have documentation of their students' information, which is kept confidential under FERPA. According to bvhsdogs.org, FERPA ensures parents and students 18 or older the right to be notified yearly of procedural safeguards. It ensures parents are completely informed of their rights about decisions regarding their identification, evaluation, or placement of their child. Procedural safeguards are given at referrals when a parent disagrees when a decision is about the identification, evaluation, or educational placement of their child. When a parent or guardian asks for information regarding their rights and on a yearly basis. Historically, FERPA impacted the field of special education for students and parents by ensuring the confidentiality of their students' records under the law. Teaching and learning became more secure because student records and information was protected. The Education for All Handicapped Children Act, according to Arizona State University, the Education for All Handicapped Children Act was passed in 1975. It was amended in 1990 and renamed Individuals with Disabilities Education Act, or IDEA. EAHCA led to IDEA. IDEA's Part B is the Individualized Education Plan. The EAHCA incorporated a Bill of Rights for students with disabilities. This bill included a student's right to a free and appropriate public education, FAPE. It is designed to meet the individual needs of the student at no cost to the family. This individualized design was created to work with the student's least restrictive environments, covered in Part B. An LRE allows students with disabilities to learn with their general education classrooms as much as possible. Enacted by Congress, this act required all public schools accepting federal money to give equal access to education for children with physical and mental disabilities. Schools were required to evaluate children with physical and mental disabilities. Schools became responsible for creating an education plan with input from parents. FAPE gave the right to carry out student evaluations for disability. According to govtrac.us, Education for All Handicapped Children Act required school districts to provide administrative procedures empowering parents of students with disabilities to dispute decisions regarding their child's education. Academic records and documents were protected by FERPA, which passed a year prior to EAHCA. The Department of Education's Office of Special Ed Rehabilitative Services made transition services as a policy beginning in the early 1980s, so EAHCA did not yet cover transition services. EAHCA led to IDEA, which covered IEPs and included individual disciplinary actions, so parents were not legally required to participate discipline. This act led to the historic IDEA, which allowed for individualized education plans which included parents as equals. IEPs made special education teachers and support staff meet the unique needs of the student as described in the IEP. IDEA. The EAHCA was amended in 1990 and named the Individuals with Disabilities Education Act. IDEA in Part B, as previously stated, requires each student who qualifies to have an IEP, FAPE, and made to work in the student's LRE. According to the National Center for Education Statistics, school districts were required to identify, locate, and evaluate students that may qualify for special education. FERPA secured all students' personally identifiable information. All students were given a free and appropriate public education in their least restricted environment. If parents or students age 18 or older want to dispute decisions made at IEP meetings, he or she may follow procedural safeguards to voice them. Students in high school are taught transition skills as agreed upon in their IEP. Disciplinary actions involve parent input as discussed between parents, teachers, and administrators. IDEA historically impacts students with disabilities, giving them and their parents or guardians more rights and resources. IDEA ensures the rights and procedures are followed as it is the law. Next is the Americans with Disabilities Act, ADA. According to STIML law, it was passed on July 26, 1990. Its intention was to fill in the gaps of Section 504 of the Rehabilitation Act of 1973. Which was described in the Minnesota Department of Education as a civil rights statute that prevents discrimination based on disability. STIML law writes ADA and Section 504, when both laws applied, would cover almost any situation, public or private, that the disabled might encounter. Title II of the ADA and Section 504 covers virtually all students who attend school, colleges, or universities that receive federal funding. ADA ensures legal coverage of students who qualify and receive special education, providing the right to an IEP, learning in their least restricted environment, receive evaluations. Parents and teachers are viewed as equal parts of the student's IEP team, providing them with safeguards and procedures, confidentiality under FERPA and HIPAA, appropriate transition services to foster independence, and follow through with discipline decided by administrators and teachers with the parents' input. This act ensures teachers will provide appropriate learning for students without discrimination. Next is the Assistive Technology Act. The Research and Training Center on Promoting Interventions for Community Living states the Assistive Technology Act was passed in 2004 and is federal law. This law was made so people with disabilities could select, obtain, and use assistive technology to enable them to work, play, recreate, and live independently. Because of ADA, IEP teams could incorporate technology deemed helpful and necessary to the student's education. Technology deemed appropriate has been made for free for students to use at school as part of their free and appropriate public education. Technology, for example, an augmentative and alternative communication AAC device, could provide a student with a disability the tools he or she needs to participate in their general education classroom as much as possible and appropriate, their least restrictive environment. New and upgraded technology can be included in evaluations according to student needs. Parents and teachers need to learn how to use new technology so they can teach their student to use it, encouraging independence. Procedural safeguards are provided to parents at least one time in a school year. Disputes about technology services can also be disputed. Assistive technology describes a student's IEP cannot be withheld for any disciplinary reasons. Technology support, as defined in the Assistive Technology Act, revolutionized special education as it allows students with disabilities the tools you need to support learning and independence. Thank you for listening to this recording, and have a good day.